Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about the US-EU Privacy Shield. The Privacy Shield was put into place to have a mechanism for companies to transfer data from the EU to the US legally because of the fact that the US does not have privacy laws that are as stringent as the EU in terms of consumers and their data. The Privacy Shield, even though it replaced the previous agreement, which was Safe Harbor, is still somewhat controversial because some people feel as though the Privacy Shield did not go far enough in terms of protecting EU consumer data that comes over to the US. Some mechanisms within the Privacy Shield framework have to do with certification of companies. So companies have to certify that they're following certain rules under this agreement to actually say that they are certified and be able to advertise that and marketing and things on their website. Some companies, since the Privacy Shield has been in place since 2018, have actually been fined for falsely saying that they were certified under this agreement and they were not. There are other ways that companies can certify or be able to transfer data that means that they don't necessarily have to do the typical certification procedure. Two of these ways are binding corporate rules, which is a company abiding by rules having to do with transferring data within their corporation. But the most popular way that companies use the Privacy Shield framework have to do with using standard contract clauses. So when the Safe Harbor was invalidated and there was no Privacy Shield for a period of time, a lot more companies started using the standard contract clauses, and they continue to do that today. One issue with the standard contract clauses that people are concerned about, especially businesses, have to do with the fact that there is a challenge with activist lawyer Max Schrems, who helped to invalidate the Safe Harbor framework. He's now have a case going on in the EU that is targeting these standard contract clauses. So people are very nervous about how this will impact businesses. Although currently in the US, we are having a stream of states and possibly a lot of talk about federal legislation around data privacy. And who knows, one day we may get to a place where this Privacy Shield may not be necessary because our laws in the US and the laws in the EU may be a bit more congruent. But for now, what we have is the Privacy Shield. It protects EU persons' data to provide what is called adequate protection. So companies that are using any of the Privacy Shield framework or the standard contract clauses, they need to understand that that does not exempt them from GDPR compliance when they're handling data. So if you think of standard contract clauses or anything within this Privacy Shield framework, it's kind of the minimum amount of adequacy to actually transfer data. So companies that are handling data of EU persons, they have to comply with GDPR as well, which is above and beyond adequacy for the Privacy Shield. So in short, the EU-US Privacy Shield is in force. It gets reviewed every year between the US and the EU. It has redress rights for individuals in the EU who feel that their data isn't being handled well. And companies are currently being looked at and scrutinized more closely if they say that they are either using mechanisms under the Privacy Shield or if they are certified by the FTC. That's it. Thank you.